Hello and a warm welcome to Federal Special Program Capital Beat. The Election Commission of India should not be given unbridled powers in implementing the One Nation, One Election system. This is what the former Chief Justices of India, D.Y. Chandrachud and Justice J.S. Khehar, have told a parliamentary committee. And both these former Chief Justices shared their observations and, in fact, gave a presentation on the simultaneous elections at the meeting of the JPC, which is examining the Constitution 129th Amendment Bill 2024 and the Union Territories laws. Now, what have the former CJIs suggested? That is very important. The former top judges suggested that the Election Commission should not be given unbridled powers proposed in the Constitution Amendment law. Then they have also suggested a system of checks and balances. In fact, ex-CJI Ranjan Gogoi also questioned the sweeping powers granted to the poll body in the proposed constitutional amendment law. Now, what we are told is that Justice D.Y. Chandrachud and Justice Khehar have also suggested to the parliamentary committee that there should be an oversight mechanism on the conduct of elections. One of the judges also said that a 5-year term for an elected government is important for good governance. And they also said that this 5-year term should not be curtailed by under any circumstances. In fact, Justice D.Y. Chandrachud had said in the past that the ability of the government to take on any meaningful project will be minimized if its tenure is only a year or less, as the model code of conduct will come into force around 6 months before the next polls. Now, the big question is that there are so many suggestions which not only Justice D.Y. Chandrachud or Justice Khehar have given, but before that, Mr. Ranjan Gogoi, Justice U.U. Lalit. But the big question is that will the government accept these recommendations? Of course, these are recommendations which will be made by the JPC, but it's up to the government to accept. Joining me this evening is top constitutional expert and veteran lawyer from the Supreme Court, Sanjay Hegde. So thank you so much for joining, Mr. Hegde. And my first question to you is, how important are these recommendations which have been made by Justice Chandrachud and Justice Khehar?
They are not recommendations. They are testimony. They are the personal opinions of the gentlemen concerned. They have been summoned as witnesses before the Joint Parliamentary Committee, which is going to make recommendations to Parliament. And normally what happens is that when there is a JPC report, on JPCs, the ruling party is in the majority. So it's not as if something which is wholly outside the ruling party's desires that comes from a JPC. So it once a JPC fine-tunes legislation, it is normally passed. The JPC will take on board all the suggestions given by the various former constitutional authorities, former chief justices. There are other witnesses also, and some of them, some of their thinking it might accept, some of them it might not. So we'll have to wait for the JPC report. Neelu, I can't hear you. Your picture is frozen. I will wait for the next question. Since the stream is live and while we wait for Neelu to come back, let me just explain what I said. A JPC which looks into any proposed draft legislation, examines that legislation, and then makes its recommendations. The JPC comprises of people from both the ruling party as well as the opposition. But normally the ruling parties have a majority on it. And the recommendations of a JPC are then considered by Parliament when they finally sit to vote on any legislation. So you may remember that during the Criminal Laws Amendment, the JPC came with its recommendations, fine-tuning various provisions of the draft, but there were dissenters, people like Mr. Chidambaram, who was part of the JPC, wrote a dissent note saying that he didn't agree with the draft on a few points, and all this, including the dissent note, is placed before Parliament. Nice. It does look like Nilu has had some major problem with her internet.
Sorry, Mr. Hegde, I'm so sorry. I got disconnected actually because of the rains, heavy rains here where I am. Yeah, please go. Yeah, sorry.
No,
Yeah.
so I did explain to your viewers in your absence also as to how there have been JPCs in the past, for instance, in respect to the Criminal Laws Amendment also. There was a
Yes.
JPC, it came with its recommendations. And people like Mr. Chidambaram, who were part of that JPC, gave their dissent notes. Everything was placed before Parliament, and then Parliament acted on the basis of whatever the JPC report was.
Right. Okay. So, Mr. Hegde, now I don't know. I mean, when this bill is going to be implemented, obviously there's a lot of back and forth happening, and a lot of stakeholders are being involved currently. But what is your opinion about one nation, one election, which Justice Chandrachud, of course, has said that it does not violate the basic structure of the Constitution? But before that, we have spoken on a number of occasions where several political parties have said that this violates the basic structure of the Constitution. In your view, does it really, the bill, if it is brought about, does it really violate the basic structure of the Constitution?
Now, see, the bill is a bill for amending the Constitution. Now, once that is passed, those amendments will have to be challenged, saying that whether they do or do not affect the basic structure. Now, just speaking theoretically, and that is possibly the level at which at which the former Chief Justice has approached it, he says that, look, having one election day specified in advance is still democracy, and we are a democratic country with free and fair elections. Then, to that extent, it may not affect the basic structure of the Constitution. However, the counter argument, and I tend to go with the counter argument. The counter argument is that we are not only a democracy, our basic structure is that of a parliamentary democracy. And it is not that a parliament which is chosen sits in for 5 years and cannot be undone, or that parliament cannot make or unmake prime ministers. This entire fallacy starts with the thing that you are going to have a government for 5 years. Yes, there will be governments over a period of 5 years. You may have one government, you may have many governments during that period. That's how a parliamentary system works, and it is incumbent on the government of the day in a parliamentary democracy to enjoy a majority in parliament at all times. This also provides for a system where if the government does something totally out of sync with what the public wants at that point of time, their members of parliament who represent them in parliament can say, no, we shall oppose this in parliament. So, to my mind, these fixed term limits, as it were, turn a parliamentary system into more of a presidential system and may likely affect the basic structure.
Okay, so you're saying that it may likely affect, right?
I would think they would, or at least that there is an argument to be substantially made in a court of law that the basic structure of a parliamentary democracy has been affected.
Right. But the other thing which has come out from the presentation which was made yesterday about unbridled powers given to the Election Commission. Now, do you think that this one nation, one election bill which is being brought about, and looking at the current form of the bill, do you think that this does give sweeping powers to the Election Commission and it has to be curtailed or it needs to be curtailed? What is your view on this?
See, the Election Commission already has a vast repository of powers. Okay. And courts rarely interfere in the Election Commission's working. So, given that position, when the powers of the Election Commission are even increased further, then the delicate system of checks and balances will get affected. And what is more, is with this obsession for this one date, one nation, one election, if something crucially goes wrong on that particular date, or if the Election Commission plays dirty on that one date, then yes, the country would be stuck with the result for 5 years. So therefore, whenever tasks are assigned to constitutional functionaries, there always has to be a mechanism of checks and balances. And that is what both the former Chief Justices seem to be indicating.
They have also indicated for an oversight mechanism. Now, what do you think the oversight mechanism should be? Because whatever we've seen in the past, and I'm totally talking from the point of view of what we have seen, how Election Commission functions and how Supreme Court doesn't intervene most of the times, whether it was the case with the VVPAT, whether it was the case with the EVMs, whether it was the electoral rolls. Look what happened with the SIR, which is being conducted in Bihar. Supreme Court normally is disinclined to intervene into the territory of Election Commission of India. So what will this oversight mechanism do? Like, say, for example, if a chief election commissioner is not conducting himself properly, there is a way out, and there is a way for the impeachment motion, but that also looks very, very far-fetched, and in most of the cases it looks very, very distant. But do you think that this oversight mechanism can be an expeditious solution to whatever problems may arise after the one nation, one election?
I'm not sure what kind of oversight mechanism has been suggested, but the oversight mechanism obviously should be, tilted towards whichever is the opposition party of the day having almost a veto on any action which is suspect. Because, you see, there is that old magic formula of PM, CM, and DM. And the DMs become very relevant, especially at the time of the counting of votes. True. Now, with the 540 odd Lok Sabha seats currently, and maybe about 750 or 800 seats when fresh delimitation happens, with each seat possibly making a difference of 2 in the majority, it would be necessary that if you put all your eggs in the same basket, that you have both the Lok Sabha and the Assembly elections being held all together, that at any stage anything substantial should only be operated through consensus of all participants. It can't be that the ruling party or even the election commission can say it's my way or the highway. So then comes the question of what would be a balancing factor. You may have one from the ruling party and one from the opposition, but then who does the swing vote? And that swing vote, I suspect that when men and women of law talk about it, they always think of a retired judge. So it is possible that that's the kind of mechanism that they had in mind.
No, but we've seen how surreptitiously things are done. They are made into a law. And look at what happened with the appointment of the chief election commissioners and election commissioners law. How it was, it was completely upended. And what we saw was that the Chief Justice of India, who was supposed to be a neutral participant, he was completely put out of the ambit. So can we assume that something like this also could be brought in, despite all these recommendations or suggestions which are being made?
Well, the current government is not known particularly for an appearance of fairness. At every stage, it has to be prodded into doing the right thing. You were speaking of the law which eliminated the need of the Chief Justice of India in the appointment of election commissioners, because the Supreme Court had brought that provision in through directions, saying that the legislature that Parliament had not passed a law. So what they did was they passed a law and saw to it that the Chief Justice was kept out of the picture. Ultimately, parliamentary supremacy or primacy is part of the Constitution. But how do you achieve that? And for what purpose? The purpose always has to be a fair working of the system. You cannot work the system in a manner where you think that it will benefit you to stay in power forever. Because then what happens is that you have very interesting consequences. Way back in the 1970s, Pakistan had never had free and fair elections except once. The only time it had free and fair elections was the 1971 election, which Mujibur Rahman won hugely, and then thereafter Bangladesh was born. Zulfikar Ali Bhutto came into power in what was remaining of Pakistan. In 1976, when it was time for elections to be conducted, those elections got rigged. The joke in Pakistan, and elections were also due in India. So the joke in Pakistan was that a message has come from Indira Gandhi saying that you can take Kashmir, but please send us your chief election commissioner. So the Pakistani people distrusted their elections and their election commissioner, and that led the way to that long, hard spell of military rule under Zia-ul Haq. What is most important in an electoral democracy is that the institutions must bend over backwards to ensure fairness and the appearance of fairness. If these institutions appear to get compromised and people lose their faith, then those elected as a consequence of those elections also lose public trust. At the heart of a democracy is the principle of the consent of the governed. If the consent is obtained by fraud or fraudulent means, then that leads to a question mark on the system of governance itself.
But Mr. Hegde, retaining the constitutionality of one nation, one election, do you see that as a big challenge? Because everybody is worried, and especially the political parties. And what if, the current newly elected assemblies, what if their tenure is curtailed? What happens next? will elections, can that mar the constitutional process? That is the big question. So is retaining the constitutionality of this bill a huge challenge? And of course, people might go to the courts again, even if the bill is brought about in the same manner.
Well, there have been suggestions as how to either extend the life of certain assemblies or decrease the life of others, so that finally you get to one nation, one election somewhere in 2030 something or the other. That is where you will finally have a date where everything can be held together. But my question is why? You may have one nation, one election at one particular point of time. But sooner or later, given the nature of parliamentary democracy, there will have to be fresh elections for some legislature, for some other place, or even the parliament, because it is not guaranteed that elections will throw up workable majorities in parliament or a legislature. You may have deadlocked parliaments, deadlocked legislatures. Then
Yes.
is it necessary that come hell or high water, you have to wait 5 years? Dr. Ram Manohar Lohia once said, "Zinda kaum 5 saal nahi rukti hai." And so that will be a major question for our democracy.
But coming to the significance of the top CJIs making observations and giving a presentation, telling the JPC about what could be good, what could be bad, how significant that is. And it's obviously up to the committee chairman, who's PP Chaudhary in this particular case, and he's going to give the recommendations to the government. How important and how marked will these suggestions be, which have been made by the former CJIs?
Well, will they be given weight? Will they not be given weight? That only the final outcome will show. But the very fact that former CJIs, and not only these two, but former CJI Uday Lalit and Ranjan Gogoi also came as witnesses, only leads gravitas to the entire process. They can say that we consulted the top legal minds that were available to the committee, and we did not prevent anyone from bringing anybody they wanted as witnesses. And we've considered all that has been told to us, and we still feel that this is the way to go forward.
No, but many times the standing committees or the government has been open towards suggestions, but then ultimately they do ultimately what they believe in. So what is the end goal of this exercise? Do you see the bill being challenged ultimately in the court of law?
It would depend on the ultimate shape of the bill when it is passed by Parliament. Okay. And I have no doubt that any constitutional amendment will see constitutional challenges. But it is one, as Shakespeare somewhere wrote, it is excellent to have a giant's power, but tyrannous to use it as such. The government may have the power to push through a constitutional amendment today, but unless it carries people along in the process, and it has to carry them till that final date somewhere in 2030 something or the other, where the exercise can be brought to fruition. So
a whole lot of challenges.
I'm not that good an astrologer to predict over a decade.
Right. Well, we'll have to wait and watch once the recommendations are given by the chairman and to the government what happens next. But yes, as you rightly said, that of course the bill looks like, in all likelihood, that it will be challenged in the court of law. So we'll have to wait and watch. Thank you so much, Mr. Hegde, for joining on the Federal. Thank you.
Thank you.